this is what they want. Okay. All right.
SJC-10740, Senator County Board of Appeals, Chatham.
I've been told by the clerk that you have agreed to to change the order of argument, and that we'll hear first from Mr. Ford, then Mr. Dane, then Mr. Riley. All right.
No, there's no such agreement.
I wasn't aware of that. I mean, I'm happy to go in any order. I'm Mr. Dane on behalf of the Chatham Zoning Board
Hold
of
on a minute.
Appeals.
Yeah. Okay, so,
I believe that I'm Daniel Dane for the Chatham Zoning Board of Appeals.
okay, so you're going to go first, Mr. Dane?
Right
Okay,
under
and you'll be followed by Mr. Riley?
Mr. Riley, yes.
Okay, and then Mr. Ford will be last. Okay.
Right, so the defendant appellees who are seeking to overturn the appeals court decision, our side has 15 minutes. We're not going to overlap on the argument. Appearing on behalf of the Chatham Zoning Board of Appeals, I'll address the standing issue for approximately half the time, 7 or 8 minutes, 7.5 minutes, and then Mr. Riley would address the merits of the zoning issue, that whether
All right.
Section 6, the benefit of Section 6.
I have a question, just a procedural one, and I'm confused. I'm sure it's my fault, but the appeals court refers to Exhibit 9, some letter, the photographs,
Yes.
which obviously are important in this case. Were the photographs part of the record?
I did not participate in the trial, so I'm not positive. I think that I was going through the record myself. I believe.
What yourself?
I was going through the record
Yeah,
myself.
and they're not
preparing.
in there.
I wasn't positive, but I thought that, I don't know if Mr. Ford or Mr. Riley knows specifically. I was taking a guess as to which photographs they were.
Well, they're not in there because I
Okay.
took the liberty of getting them because I thought that was sort of important, and they're not in there. I have a packet of pictures that are not, anyway, to the extent I can find, anywhere in the exhibits. And there are 4 or 5, I think 6 or 7 photographs that I think are quite important to somebody reviewing the case, and I don't understand whether it appears they were before the appeals court because the appeals court acts, or their decision speaks, it reads as if the appeals court justices had seen the photographs. So that's why I'm wondering whether they're in the record, what the story is.
I'm sorry, Your Honor, I'm not able to address that question.
Maybe one of the other attorneys
I
can. It's just-
participated in this appeal at
Okay.
the briefing to this court and wasn't familiar and didn't participate in the compiling of the appendix in the trial.
Your Honor, please, it's in the trial exhibits,
Oh.
page 168.
It's 9H in the. Did I have those? Did I have? Okay. All right, fine. Thank you. We'll find them then. Thank you. Okay.
All right.
With limited time, I'll go quickly. Just very quick background. This is a proposal to rebuild a house in Chatham. Same footprint, same 2 stories. There was a need to rebuild the house due to flooding and mold issues, I believe. And in order to comply with FEMA floodplain regulations, the house as proposed would be 7 feet taller than the existing house, but again, on the same footprint. This is not a McMansion. We're talking about the new house being approximately 1,300 square feet. At trial, if you read the trial transcript at page 71, Mrs. Kenner testified that the 7-foot marginal increase will have an impact on our views and vistas from their front porch.
Now, isn't the core issue whether or not the issue was whether minimal is enough or whether it must be substantial or significant?
I think there are a number of issues. In a standing analysis, there's really two-part inquiry to the court's analysis. The first inquiry is whether you identify what the range of harms are. It might be traffic, it might be view, it might be parking. And so then the first inquiry is that identification of a harm a legally cognizable harm? In this case, the identification was view. If it is legally cognizable, then the second inquiry is the quality and quantity of the presentation at trial or on a 12b1 motion for lack of jurisdiction, does that then suffice to establish a legal agreement under General Law, Chapter 40A, Section 17? So on the second part of the inquiry, as to essentially the quantum of the presentation, I do think clearly a core issue is it minimal, is that enough, or I think the term by the appeals court was appreciable impact, or must it be a substantial injury? And I think that this is a question that does call out for this court to address and clarify, because there is different standards have been used by different courts. I think that the quantum was first addressed in the Boston Edison versus Boston Redevelopment Authority case by this court in 1978, I believe. This court said that it must be a substantial impact in order to establish an aggrievement. Since then, quite a few courts have talked about the quantum. For instance, if it's a loss of light and air, it has to be a near total deprivation of the light and air. That would certainly imply some substantial amount, not just, well, we're going to have a little bit less light. With traffic, there's some variation among the courts, but more recently the trend has been to require some, if traffic is going to be the basis, it would have to be some substantial impact on the person in order to have the quantum of evidence necessary to establish legal agreement. And I certainly think in terms of the administration of the courts, particularly we see with the land court having an enormous number of 48 cases, the land court has been, I think, fairly aggressive in protecting its docket and accepting only the cases where there is an actual substantial legal agreement. And I think a lower standard, a minimal impact, would open the door to just about anyone and not be consistent with the court's gatekeeper duties under a 40A analysis. The first part of the inquiry is whether it's a legally cognizable injury, which I think is also important for this court to address. The issue is queued up by this court's decision in the Martin versus Church of Jesus Christ of the Latter-day Saints case in 2001. And I'll just quote from it briefly because it cues up the issue. Generally, concerns about the visual impact of a structure do not suffice to confer standing, and we are not persuaded by the judge's reasoning on this point. But Belmont's zoning bylaw itself provides that the board should take into consideration the visual consequences of any proposed structure. Subsection 1 of Section 7.4.2c of the bylaw provides that views from public ways and here's the key language, developed properties should be considerately treated in the site arrangement and building design. So in other words, what Martin was saying is views are not typically a legally cognizable basis for standing, that it can become one if the zoning code itself particularizes an injury. And so the question that becomes that I think this court, it makes sense for this court to clarify is what language is necessary in a local zoning code in order to particularize an injury so it's sufficient to provide a basis for standing.
The land court did not so find, I gather.
The land court noted the issue and then seemed to skip over it. I think it's still before the court. Certainly the appeals court addressed it, and because standing is a question of subject matter jurisdiction, it can be raised at any time, including on appeal. So I certainly think it's appropriate for this court to address. In the Martin case, it talked about taking into account views from developed properties, which would indicate that it's particularized to a particular property. I cite a number of land court cases where their practice has been, if the language is more general, that is not enough. In our case, the Chatham bylaw talks about the visual character of the neighborhood, and certainly the presentation by the Kenners at trial did not put on any evidence as to the impact on the visual character of the neighborhood. I think visual character of the neighborhood would be things like, it's a community of Cape Cod houses and someone wants to build a huge house that house is not in keeping with the visual character of the neighborhood. There's no evidence that the Chatham zoning bylaw, section VB5, indicates an intent to protect specific views from a person's home. And in fact, if you look at Chatham bylaw section VB2, by contrast, it actually uses language taking into consideration certain impacts on private homes, but not in the context
Mr.
of
Dane,
views.
now, you were given 7.5 minutes. I know we took several minutes of your time to sort out the photographs and all, but you're going to have to start to wind down.
I guess just wrapping up then. So the issues for this court to address are legally cognizable. What is language sufficient to indicate that a municipality intended to create a legally cognizable protectable interest from a private home as opposed to the general neighborhood? If once a appellant gets past that issue, then the question is the quantum of the evidence, which has to do with, is it substantial or is it appreciable or minimal? Does there actually have to be a harm? Does there have to be testimony that there was a harm from this? Or does it just have to be an impact, which is the language that the appeals court used? There's a question as to Judge Trombley took a view in this case, and the appeals court said that the view was essentially not appropriate, but the case law talks about judging standing based on all of the evidence and whether the evidence is credible. If someone simply stands up at trial and says, you know, my view is going to be blocked, it certainly seems appropriate for a trial judge to...
Why would a view be even relevant if the question is what the bylaw was intended to protect?
Well, right. So if the bylaw was not intended to protect views, then the analysis would stop there.
Then the view that the judge
Right.
took wouldn't even be relevant.
No. View has two different meanings.
No, I'm saying when the judge went out to look at the
Right.
property, if the bylaw were not intended to protect the sight line from private property rather than the character of the neighborhood, it wouldn't even matter.
It wouldn't matter. Once you, if it wasn't intended to protect, if the bylaw doesn't intend to protect views, then you wouldn't need to get into the quantum of the evidence and whether or not the judge takes a look at the view and determines that the testimony about view was not credible. In this case, if you look at the map in the exhibit, it shows that the Kenners had an entire panoramic view of toward the Chatham Harbor, and this is one house some distance away, slightly downslope. We're talking about 7 feet, and the judge goes to the scene and says, I've looked at the scene, this is just, if it's any impact at all, it's minimal, and certainly not enough for standing. And I think the final issue for the court to consider is clearly erroneous, rationally and definitely makes clear that findings of fact in the standing analysis are entitled to the clearly erroneous standard. The question is, when a judge makes a judgment such as minimal or substantial, does that get clearly erroneous standard of review? We would argue that it should, because that is sort of the heart of the standing analysis. There is some judgment that goes into whether or not the standing standard is met. If you're just talking about cold facts, okay, I understand.
Thank you.
Thank you.
Good morning. William Riley on behalf of V.J. McKenna Hyde and Lewis Hyde, the property owners. This is a situation where there were 4 cottages built in the 1940s and early 1950s before Chatham had a zoning bylaw. In 1980, they were purchased by a person who recorded the deed of condominium. After the units were sold, one of which went to the Hybes, and about over 10 years after their ownership began, the property owners decided that they would rather have separate ownership rather than condominium ownership, and so they were advised that they could have the property divided using a plan, which we refer to as an 81L division plan, where by statute you can divide a property without regard to zoning requirements if the structures located on the property predated the adoption of the subdivision control law by the town, and one structure remains on each lot. And so the result was that in 1999, the property was divided, and the individual homeowners had individual ownership of their units rather than condominium. The appeals court found that the 81L division stripped the Hyde property of its protected status under Section 6 of Chapter 48, the second accept clause that provides special protection for single and two-family residences, requiring only that they obtain a special permit on the determination that the proposed change to the structure was not substantially more detrimental to the neighborhood. Obviously a much lighter standard than the variance standard. And so the consequences of that determination by the appeals court is that properties such as the Hives end up being relegated to sort of an orphan status where they can't be significantly upgraded or...
But they bought that property and they subdivided that property with knowledge of that.
Well, with all due respect, I don't think the individual property owners had any idea that the recordation of the 81L approval not required plan was going to change the status of their property from one that's protected by the second accept clause of Section 6 of 40A.
But the approval not required isn't intended to overcome the zoning bylaws.
No, we understand that, and we certainly don't argue with that. But there's nothing in the case law or the cases or the legislator that the recordation of that plan is going to strip you of your status. We acknowledge that when somebody changes their property, particularly with the A&R kind of plans that are referred to and relied upon by the appeals court and the appellant, where they were attempting to create new buildable lots. In all the cases cited by the appellant and by the appeals court are cases of that nature. Here we have a situation where there's an individual home on each lot. In this case, in particular, there's no proposal to expand it, expand its footprint. And so where you had 4 non-conforming residences prior to the recording of the plan, how is a homeowner in particular to know when there's no case law that says that this previously existing, lawfully in existence as required by Section 6, is going to lose its status under the second accept clause?
Because by now the new zoning bylaw has been adopted.
Yes.
And so they're changing their property and by subdividing it, so they know that I would seem to me that they are on notice that they're subject to the now existing bylaw.
Well, I think it was the policy of the town of Chatham that they were not. I mean, the reason that the appellees are the town of Chatham and the property owners, the town of Chatham had a policy that was exactly in accord with what we're proposing here today. And
Well, aren't there some decisions of the appeals court right on point? That's some prior opinions of the appeals court?
No, there aren't. The earliest case that I could find was the Smalley versus Town of Harwich case, and that talked about the fact that the lot has no zoning protection. All the cases that they have talk about the fact that the lot has no zoning protection. What Smalley says as well, it shows a zoning violation, but it doesn't say, as a consequence, the structure that's located on the property no longer is protected under Section 6 when it's a single-family residence. And I think that the refusal by the appeals court and the applicant's proposal that Section 6 and 81L not be read harmoniously really does damage to the protection that the legislature intended for single and two-family homes under Section 6. I think that it's a very important, as I say, policy argument.
What about the appeals court case Alley versus Building Inspector of Danvers, a 1968 case?
That was a case where the
says zoning protection granted to pre-existing houses does not allow owner to reduce lot size below the required minimum.
Well, that was
Approval not required endorsement by planning board provides a lot no standing under the zoning bylaw.
That's it, provides a lot no standing. And that was a case where they were attempting to create a new building lot, as all the other cases that are cited by the appeals court and by the appellant.
So, just so I'm clear, what they did in this condo unit was essentially make them 4 individual lots for the 4 homes.
That's correct.
And tell me if they had done something else, then they would have lost their zoning protection. Tell me what they would have had to do to lose it, because you claim that what they did not cost them.
If they had divided the property in a manner that was designed to create an additional building lot, then I would agree with the previous, with the cases cited by the appeals court and by the appellant. But this is, I mean, we had 4 individual structures. They were non-conforming. This is a single-family residential district, and it was a non-conforming. The structures were all non-conforming physically. The use was non-conforming. I mean, arguably, the division of the property into 4 individual house lots, each with a single-family residence on it, actually made the property more conforming than prior to the recordation of the plan. It's unfortunate that that the town's position did not alert the homeowner in any way to the loss of protection under Section 6. But I think that it's when people are trying to design their retirement homes, and it's very important to them that a modest change like the one proposed here should not cause the property to be really a drag on the value of the neighborhood. I mean, one of the things that's happening, at least in the town of Chatham, I can tell Your Honors, is that the updating and modernization of homes from 1940 summer cottages to 2010 accommodations is a significant part of our commercial activity. And when one house can't be upgraded, it tends to drag the whole neighborhood down. I think that's part of the rationale for why the town has adopted this policy and why we would urge this court to adopt it as well.
In Brannigan versus the Zoning Board of Appeal of Falmouth, the appeals court said, because the endorsement of an A&R plan indicates only that the plan does not depict a subdivision, enforcement of the local zoning bylaw is not precluded. The lot is new at that point and loses the protections afforded to pre-existing non-conforming structures.
Right. The Brannigan case was decided after we had briefed our case and filed with the appeals court.
But it does cite other cases for its proposition.
Every single case cited there, just like all the cases cited in our case, are cases which called for the creation of additional building lots. This case is the first time that the issue of the protection of the structures, particularly when there's no expansion. I mean and what's the policy? I mean, how do we lose the most productive and the greatest value of the property because now it's frozen, that you can't change things because you need a variance, and you can't get a variance because it's a self-created hardship because you or a predecessor in title recorded an 81L division plan. I don't think it's good use for the housing stock, and it certainly doesn't make any sense from a municipal.
Mr. Riley, we're going to have to leave it there. Thank you very much.
Thank you very much.
Good morning, Your Honors. Michael Ford, appearing for the appellants, Mr. and Mrs. Kenner. First, with respect to the issue of standing, it seems to me that the first consideration was the fact that the Kenners, being owners of property directly across the street from the Hyde property, were entitled to the presumption of standing under Chapter 48, Section 17. And under the cases, unless direct evidence was introduced to rebut that presumption, then their person's aggrieved and they have standing. In this case, as the review of the record will reveal, the Hives case involved 3 witnesses. One was a house designer, one was a civil engineer, and one was an abutter who was asked simply to identify some plans. In addition to that, the court conducted a view. I would respectfully suggest that there is nothing in the record that amounts to anything close to direct evidence that rebutted the presumption afforded the Kenners by statute under Chapter 48, Section 17. The Kenners, during their course of the trial, in addition to testifying themselves with respect to agreement, also had the testimony of an expert appraiser.
Let me ask you this. I understand what you're saying about the presumption and no evidence to introduce to rebut it. But if the question is a question of law, whether language is sufficient in the bylaw that the municipality intended to protect the view from a private home rather than the character of the neighborhood, then would they need evidence to rebut the presumption?
Respectfully, Your Honor, I don't believe that you ever get to the question of the bylaw and the protections afforded if the presumption afforded by statute is never rebutted. And in this case, it's very important that after the Kenners expert testified with respect to diminution value, which I'll touch on in a moment, the court agreed and offered the opportunity to the Hives at a later date, extended the trial to allow them to introduce an expert on the question of value, presumably to afford them the opportunity to undertake the rebuttal set out by the Standerwick case. They did not comply and later informed the court that they weren't going to provide any further evidence. The case was closed and the court went to decision.
Okay, but the basis for their claim of standing was that they said this will diminish our view of the sea, correct?
It was.
And if that reduction in the quality of view is not viewed as a cognizable harm, because the Chatham bylaw speaks of it being a neighborhood visual character as opposed to interference with the ability of a private structure to have a view, why would they have standing?
Well, I would still stand on my response to Judge Corwin that you don't get to that question of cognizable harm if the presumption has never been rebutted. However, to get to the question of cognizable harm...
But maybe you wouldn't get to the presumption of standing if you have the purpose of the bylaw is the very first thing.
Well, no, the statute says very clearly, 4817, that abutters and abutters to abutters and those directly across the street are presumed to be persons aggrieved and have standing to bring an appeal. That presumption may be rebutted if direct evidence is introduced by the defendants in the case that rebut that presumption. It is only then that the court hears all of the evidence, including the intent of the bylaw and what the protected interests are, and then makes a determination of standing. But if the presumption is never rebutted, you never get to that question, respectfully. That's the way I read the provision for the presumption in 17. But with respect to the protected interests under the bylaw, I don't think that the bylaw has been fairly characterized in the presentation to you. It is laid out on pages 62 and 63 of the trial transcripts that are part of the record. And Judge Cohen, those trial transcripts, because my office prepared them, also include all of the pictures about which you had a question earlier on. Here's what the bylaw says, and it's interesting because you have to put it in context. The section in which this language appears is a section entitled Nonconforming Lots, Buildings and Uses. And it sets out 3 purposes in the beginning of the section. While all of them are important, I want to draw the court's attention to the second purpose. The second purpose says, to avoid the creation of adverse impacts on neighboring properties or on natural resources. So right away there's a goal set forth in the beginning of this section under which special permits are deliberated, and that goal is to avoid the creation of adverse impacts on neighboring properties. Why? Because you're dealing with a change to something that's already non-conforming. And so there's a heightened awareness of the legislative body in adopting this section that adverse impacts to a neighboring property should be avoided. We then get to the section that I would suggest does give the protected interest. And that section reads, that they have to consider impact of scale, siting, and mass on neighborhood visual character, and then it goes on, including views, vistas, and streetscapes. I'd respectfully suggest that the Chatham Board of Appeals, in its decision, looked at views from the neighboring properties of the project that was proposed, and that that's the true meaning given to that. And the trial court didn't quarrel with that. Indeed, the issue was never raised at trial as to whether views were a protected interest. Indeed, when we went to the appeals court, and the appeals court reversed the trial judge on the issue of standing, this issue was not argued there. Now, I know that my brothers indicated that subject matter jurisdiction can be raised at any level, and I don't quarrel with that that's the case. However, in this case, they're now going back for an interpretation of the bylaw, which is kind of a subsidiary finding that you have to make in order to get to challenge standing, which is the thing that promotes subject matter jurisdiction. And I call the court's attention to a case that was not cited in my brief. It's an appeals court case that came down in late 09, 74 Mass App 804. It's Hoffman versus the Cambridge Board of Appeals. And in that particular case, which also went before this court on an application for further appellate review and was denied at 455 Mass 1104. And in that particular case, the defendants attempted to raise, at the appeals court level, facts that went to the issue of standing. They had raised standing as an issue at the lower level, and they had raised it at the appeals court, but they had not raised a particular argument that would add to their standing argument or lack of standing. And the appeals court in that case, in Hoffman, rejected it and said it was not raised at the trial court, and we will not entertain it here. And I'd suggest that Hoffman is instructed as to whether the issue of a protected interest is even before you. The appeals court, my brothers argue, glossed right over the question of whether a view was a protected interest. Again, it was never raised. It was never a question that was actually before the appeals court. But having said that, the appeals court is very specific that their finding of standing, they didn't have to go any farther than an inquiry of looking at photograph 9H. For them, photograph 9H, which shows the Kenner house, which is directly across the street from the Hyde property. The Hyde property fronts on the ocean, so there's Nantucket Sound, this cottage, which is only 12 feet high, the Kenner's house. It's been represented that the height increase in their Kenner's house is a result of the floodplain. It's not true if you read the record closely. The base flood elevation as contained in the record is elevation 10. The current house, the cottage, sits at elevation 11 at the top of foundation, and then it is 12 feet higher than that. On the new house, sits at elevation 13 and is 12 feet higher than that. On the new house, so it's 3 feet above the floodplain currently on the first floor. The new house is at elevation 11. So they've lowered it 2 feet because the base flood elevation is at 10. So to simply suggest we're in here simply to comply with the floodplain doesn't add up with the facts in the record.
But do you agree that the appeals court had a different view as to what the magnitude of harm must be as a matter of law to get standing?
Well, I did. I think the appeals court looked at a number of decisions in which the appeals court, and I'd suggest this court, has differentiated between the evidence necessary to get into the courthouse door, to actually bring the appeal, and the evidence necessary to prevail on the merits. And I think where the appeals court felt that the trial judge in this case incorrectly applied that standard, he mixed the two up, respectfully. The appeals court said that in finding whether or not the Kenners had an injury, it wasn't necessary that they necessarily proved that their allegations with respect to harm were true. They simply had to make a credible showing that indeed there was some harm. And I'd suggest that the facts in the transcript are that they did make that credible showing. They made that plausible showing, as the cases have suggested. In other words, you don't have to prevail on the merits to have standing. which is what the judge seemed to do, in which the appeals court corrected and reversed.
Do you agree that if the judge were correct in his evaluation as to the magnitude of harm, then the factual findings he made in support of that were not clearly erroneous?
No, I think in this particular case, the picture showing an increase in height from 12 feet to 19 feet, and we're dealing with a substantial increase here. If you look at the pictures of the existing cottage in the record, and you look at the proposed three-level house in the record, it seems to me that the judge's findings that that was de minimis, given the view from the Kenner's property, are incorrect.
Okay, but that's my, I guess, but he didn't find that de minimis was the proper standard, did he?
No, he didn't. No, he didn't find de minimis was the proper
So
standard.
if he found it had to be significant or substantial, I forget what the language was.
Right. He felt it had to be a substantial effect on the Kenners.
And if he is right, and I don't know whether he's right, but if he is right, do you agree that his factual findings are not clearly erroneous, especially in light of the fact that he went there?
He did take a view, and we still disagree, respectfully, Judge, with his findings that they were clearly erroneous. That if you look at the pictures, you look at the trial transcript that came in, if you look at the evidence, the judge's findings simply don't add up to what was in the record, and from that point are clearly erroneous as to the evidence that was before the court. That is still our position, Judge. Finally, with respect to standing, the appeals court, while they said they never had to get beyond the picture of 9H, didn't have to get to the other basis for standing that the Kenners brought forward at the trial. One was the fact that this is a one-lane road. In order to reconstruct this cottage, it's necessary for the Hybes to create a retaining wall right along the edge of the road. There'll be an inability of cars to pull off, and the court found cars by necessity will have to pull into the Kenners driveway. That was another basis on which we suggested standing.
Let's assume you have standing for a moment. Let's move on to the issue of the merits. Why does it make sense for the fact that they chose to change from a condominium into individual lots, that as a result of that, they, for all practical purposes, lose the ability to do any meaningful renovation of their cottage?
Well, I think in the first instance it's important to review just briefly, before I answer that, the evolution of the Hybes house. It was purchased as a condominium, and in the transcript are the condominium documents. And at page 119 you'll see that part of the condominium documents, in the master deed, when they bought it, there's a specific statement, paragraph 8, that says, no unit shall be occupied as a year-round residence as defined by the Chatham bylaw. This is what they were on notice of when they purchased this property. That's what's in the record. What happened here is that you had a seasonal cottage colony developed by a prior owner on a 1.4-acre parcel of property that fronted the ocean. All of the cottages were constructed in the early 1950s and used as rental seasonal cottages. They were then subjected to the provisions of the Condominium Act in the 80s and sold off as individual condominium units. A cottage colony is a defined use in the Chatham zoning bylaw, and it is defined as seasonal rental cottages. It was viewed as non-conforming and apparently was able to be condominiumized, and they were sold off as individual units. But I'd suggest respectfully, with the full knowledge, that they were not single-family dwellings as that term was used in the Chatham zoning bylaw. Then what happens? 1999, they're advised by a land surveyor that they can take advantage of the provisions of Massachusetts General Laws, Chapter 41, Section 81L, which in the definition of a subdivision provides that a division of a tract of land into two or more lots, each of which has on it a structure that predated the adoption of subdivision control, is deemed not to be a subdivision. Now, my brothers indicated that when such a subdivision occurs, the statute says it can go forward without reference to zoning. It doesn't say that anywhere in there. That is simply another exception to the ability to divide property. Divide property, not subdivide the property. Now, our position, Judge, is that once that plan was recorded, and that was a voluntary act, by unit owners that knew in their master deed that what they had bought, they had acknowledged, were not single-family homes under the Chatham bylaw. That's a voluntary act which they now come forward to this court and say, our rights are being taken away. Well, the rights aren't being taken away. And what has changed from a zoning perspective? From a zoning perspective, rather than a 1.4-acre lot with 4 seasonal rental cottages, you now have 4 lots, none of which meet zoning. This is 1999 when this plan gets recorded. The minimum lot size is 20,000 square feet. This lot has 2,200 square feet of buildable upland.
Mr. Ford?
Yes.
Time is up.
I rest on my brief for the remaining arguments. Thank you, Judge.